The National Children's and Youth Law Centre, in conjunction with the Australian Catholic University, have created a series of videos to assist students and young people to understand their rights and responsibilities as a tenant. If one of my co-tenants damages our rented property, who's responsible for the damage? John lives in a shared house with his co-tenants Bob and Mary. They contribute equally to rent and bills, and they all have their name on the residential lease. One night Bob invites his friend Mike over for a few drinks. Bob and Mike have a few drinks too many and have an argument over who's going to win the football grand final. Bob punches Mike, who dodges the punch. Bob's fist hits the plasterboard and makes a hole in the wall. Mike is so angry that he kicks the door as he leaves and shatters the glass. John and Mary want to know who has to pay for the damage. Each co-tenant is responsible for paying the rent, bond, and for any damage to the house. If there is unpaid rent or damage, the landlord can ask any of the tenants to pay for it, even if they didn't cause the damage or it wasn't their rent that was late. When Bob, John and Mary signed the lease, there was a guarantee from the landlord about a couple of things. First, that the house was clean and fit for habitation. Second, that the property would be kept in good condition. Third, that repairs would be made in good time. And finally, that a condition report would be provided. A condition report shows what the house looked like when the tenants moved in. It should note things like any existing damage, what appliances were provided when you moved in, etc. When they signed the lease, Bob, John and Mary would have also promised the landlord that they would keep the place reasonably clean. At the end of the lease, make sure the place is as near as possible to how it was when they moved in, excepting any fair wear and tear. Tell the landlord about any damage as soon as possible, and not to damage or allow someone else to damage the place deliberately or negligently. This means that Bob, John and Mary have to repair any damage and pay for it themselves. This includes damage created by one of their friends or visitors who have been invited there. If Bob, John and Mary don't repair the damage, the landlord can get the amount it costs to repair taken out of their bond. This could mean that no one gets any of the bond back if the damage is the same as or more than the amount of the bond. If this happens, John and Mary could ask Bob to agree to pay their share of their bond back to them. If this doesn't work, they'll have to take Bob to the local court to get the money back as a debt. They couldn't go to an informal tenancy tribunal because the argument involves just other co-tenants and doesn't involve the landlord. Remember, everyone's lease and rental questions are different, and the law changes often. If you have a specific question about your housing arrangements, please send us an email. You can read more about the National Children's and Youth Law Centre and what we do by visiting the web address provided. The information contained in this video is general and is not intended to be advice on any matter. If you have a specific question, please email us at the details given.